Good morning, everyone, and welcome to today's Beasley Allen webinar, Building an Acetaminophen-Autism ADHD Case. My name is David Byrne, and it's my pleasure to introduce our three speakers for this very important litigation topic. Today, my partners Roger Smith and Ryan Duplechin, along with Mary Cam Raybon, will discuss the growing litigation involving these acetaminophen products. They'll discuss the scientific links between acetaminophen use during pregnancy and autism and ADHD. And finally, they'll walk you through the building blocks of a solid injury case. So while we're waiting on the last of our registrants to join us, let's take just a few moments and meet our three speakers. First, my friend and partner, Roger Smith, is a longtime leader in Beasley Allen's mass tort section. Since joining the firm in 2001, Roger's dedicated all his time to complex litigation involving pharmaceutical products and medical devices. Among other things, Roger served on the teams that negotiated the $4.85 billion Vioxx settlement, as well as the $2.4 billion Actos global settlement. He's also served as lead attorney in numerous cases that resulted in multi-million-dollar settlements for clients with claims related to things like Resolin, Cerazone, ephedra, PPA, herbal supplements, gadolinium, Yaz, Yasmin, and Fleet phosphosoda. Of course, over the past 2 decades, Roger has served on a lot of different MDL committees and subcommittees, and most recently, he was appointed to the Plaintiffs Executive Committee for the Acetaminophen-Autism ADHD MDL. There, he serves as lead counsel for the Science and Expert Committee on Acetaminophen. Roger is a remarkable legal and scientific scholar, and we are so delighted to have him on our team. Next, my partner Ryan Duplechin is another truly outstanding member of Beasley Allen's mass tort section. Since joining the firm, Ryan's litigated cases involving joint replacement devices, dietary supplements, and pharmaceutical drugs like Xarelto and Belviq. Ryan currently serves as the vice president of the Alabama State Bar's Young Lawyers section, and he's a member of the Bar's Leadership Forum. In addition, Ryan has served as lead attorney in oral arguments for a number of federal and state courts throughout the country, and he's authored some of the key legal publications and briefs that have been critical to the success of our clients' cases. Ryan's a huge asset to Beasley Allen, and we are happy to have him with us today. Finally, my friend and colleague Mary Cam Raybon is also an attorney in Beasley Allen's mass tort section. Over the past several years, Mary Cam has actively worked on high viscosity bone cement cases, baby food contamination cases, as well as claims involving defective dietary supplements and weight loss drugs like Belviq. Mary Cam graduated cum laude from Huntington College and received her Juris Doctor from Samford University. Mary Cam is an absolutely tireless advocate for our clients, and I'm so delighted to have her join us today. Now, before I turn the program over to our speakers, I do need to go over just a few housekeeping notes with our audience. First, today's webinar has been approved by the Alabama and Georgia State Bar for 1 hour of CLE credit. In order to receive full credit for attending, you've got to stay on for the duration of today's program. A link to the presentation was included in the Zoom confirmation email each of you should have received when you registered, but no worries, by the end of this week, you're going to receive another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys who are participating by phone, please email us your name, phone number, and state bar ID number. You need to send that to webinars@beasleyallen.com to ensure you receive full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we'll be adding more webinars throughout the year. Last but not least, if you have questions during today's webinar, and I know that many of you will, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, Roger, Ryan, Mary Cam, let's get started with today's program.
Thank you, David. So kind of as David mentioned, we're going to start off with, I'm going to give a litigation overview, and then Roger's going to get into the acetaminophen story and science, and then Mary Cam will kind of talk about what a good potential good acetaminophen case looks like. So as far as a litigation update, I know we did a similar webinar, maybe or coming up on a year or so now, but a lot has happened in that time, and so I'm going to give you a little bit of update on that. So I'm going to talk about kind of how we got here, and then the legal hurdles along the way, and then where we are now. So as far as how we got here, I know some of you are familiar with mass torts and how it starts, but it a lot of you, you kind of see the MDL headlines kind of once it's already formed, and so kind of what usually happens is that we kind of notice a trend in medical literature, or there's a recall of a certain drug or device. And so that happened here. So we started seeing a trend in the medical literature late 2021, early 2022 about acetaminophen exposure in pregnancy. And for those who don't know, acetaminophen, the most recognized one is Tylenol. And so acetaminophen is the main ingredient in Tylenol. If you see that the MDL headline is in re acetaminophen ASD/ADHD litigation, the ASD is autism. And so we're talking about essentially Tylenol, products like it, connected to ADHD and autism. And so we started seeing that trend in medical literature. Also, as far as in kind of the scientific community, if someone is going to be the first or the second to say that something is caused by something else, I've come to know from doing this kind of work that they are really putting their name out there and really putting themselves on the line. And so as we all know, there's strength in numbers. And so in late 2021, there was a consensus statement that about 90 scientists, public health professionals, and others signed on to that were saying, okay, there is something here. We are seeing something in the medical literature that is connecting acetaminophen to these neurodevelopmental type issues. And that was in late 2021. And so fast forward to mid 2022, we started, getting a working group together with some firms and filed a few cases at that time in federal courts, and decided to petition the JPML. So the JPML is the U.S. Judicial Panel on Multi-District Litigation. That is the first step to creating an MDL, a multi-district litigation. And essentially, they would consider things like how many cases are there, where are you wanting this to go, what judges have the capacity to take this on. And so that was in September 2021. We went up to St. Louis and argued that, and the JPML ended up sending it to the U.S. District Court for the Southern District of New York. And that is where it's pending now in front of Judge Cote. And for those who don't know, the Southern District of New York is one of the most famous district courts. It's where it's right next to Wall Street. It's where Bernie Madoff happened. There's significant terrorism type cases and huge financial crime cases that are there. And so that the courthouse is massive. It's really awesome, and I don't know, just it holds a place in a historical sense in the law. So that's where it is. It's in front of Judge Cote. And so things happened very quickly in this MDL in general. And so the first general thing that a judge will think about in an MDL is, one, who is going to be the leadership attorneys. And so there's tons of cases filed all over the place, and they get centralized in this court. And who are going to be the ones that are the main point persons that I as the judge can communicate with, who can get this information out to others, and who can create a hierarchy of who will handle what. And so that was the that was the first order of business, leadership. And then the second one is creating an initial case management order that kind of, it lays out an expectation for where this case is going to go, how things are going to proceed, and how, and it really tries to project early big issues in the case, so the court and the judge can try to steer that in the right direction and possibly decide something relatively early. And so what we saw in that case management conference was, I mean, something that we expected. The defense counsel, and so to jump back a bit, so Johnson & Johnson is in this case because Tylenol is made by McNeil, and well, now Johnson & Johnson Consumer Inc. And so, but there's several other acetaminophen manufacturers. Johnson & Johnson's, I guess, legal defense team, I mean, seems to be taking quite a bit of a lead role as far as strategies and everything. And so we saw some lawyers up there that we, in that courtroom, that we see often in other types of MDL cases like this. And they were essentially telling the judge, hey, there's no science here. This is all made up stuff that they always say. And then and by the way, judge, there's a big preemption issue. And so this whole MDL, like, we could litigate for years and just, it'll cost us tons of money, and this stuff's preempted anyway. So we should go ahead and do that. So Judge Code essentially said, okay, well, that preemption ruling, that is something that we can do without, I guess, an extensive amount of discovery. She did want to see certain things from the FDA, I guess, but that's something that she decided that we should do early, is that preemption briefing and ruling. And so it also started to get into her mind at that point that we could do the big science question first, which turns out to be phase 1 discovery, which I'll get into in a bit. But as far as the number 2 thing, the legal battles along the way, it kind of segues into preemption, which was the first major one. And so that was teed up almost immediately. And so, I mean, in general, people like to think that preemption is this super difficult analysis, and it's reserved for the best appellate lawyers in the country, and only they understand it. But it really can be simplified. And so where preemption comes from, the idea is that it comes from the Constitution, the Supremacy Clause, that says that federal law should be the law of the land, essentially. And so if you have a state law that conflicts with a federal law, then that kind of produces a preemption defense, preemption argument that defendants try to make. And so it's something that's been very well resolved as far as drug and device cases. There's been U.S. Supreme Court cases on it. But what we're talking about here is an over-the-counter medication. So it's not prescribed, so it's not FDA approved. Which your first thought is, well, if it's not FDA approved, then why is there preemption anyways? But so in this particular sense, there are these FDA rules for what a over-the-counter medication should have to say on the label. And so one of them is consult your doctor during pregnancy. We call it the pregnancy consult your doctor type of language that goes in there. So although preemption can have these 60-page long briefs on both sides, the core of it is that FDA regulation monograph that said your over-the-counter medication has to say consult your doctor. The defense says that is the limit. That's all we have to do, and we've complied with it, and we're not even allowed to add more language to it. And then what the plaintiffs are saying is, no, that is the floor. That's the minimum that you have to do, and you should be adding more language to adequately advise women about this risk during pregnancy of neurodevelopmental issues, autism, and ADHD. And so that is the core of the preemption argument. They say that FDA regulation says that's all we have to do, and even if we wanted to, we could not add that more language. But there's several case law and things that we put together that we believe shows that is the minimum that they would have to do, that they could add more if they wanted to. And Judge Cote in the Southern District of New York agreed with us and denied their motion for preemption on those grounds. They filed a reconsideration. It was denied again. And they have recently filed a motion that they want to take it to the Second Circuit Court of Appeals, and they want to do it immediately during the middle of the litigation. We've filed a response saying, of course, that's not necessarily necessary. It'll cause delay, et cetera. And so that's still looming at the moment. Another one, I guess the second big legal type of argument we've had was more related to individual cases from certain states. And so in mass torts all the time, we deal with, okay, this state law says this and this one says that, and it's quite, I mean, coincidentally, I guess we know that states like Texas, for example, would have less favorable laws for consumers, for plaintiffs. And so this particular I guess legal battle that I was alluding to had to do with Texas plaintiffs. And so at, I guess, big picture overview, we all know that there's three types of defects. There's design, manufacturing, and warning defects. So this deals with warning defects. Most all drug and device cases deal with that third, the warning defects. And so there are some state laws that say, here, I'll back up for a second. So failure to warn, one of the fact questions is whether the warning was adequate, whether it adequately communicated that risk to that person, and so that it triggered something in their mind so that they could decide on their own if they want to take that risk. And so there is there's only a few states that have passed kind of pro manufacturer type laws that have put a presumption on that adequacy. That have said there's a presumption of adequacy, and the plaintiff kind of has to overcome that. And so Texas actually had a specific thing in their law that said that if an over-the-counter medication complies with the FDA's monograph regulation that we talked about, then that is adequate as a matter of law. And so since Texas had that state law that said that, there was really nothing that Judge Cote could do. And so she ended up creating that one where the failure to warn claims for those Texas plaintiffs would at this point would likely not be able to go forward. And so the third part is kind of where we are now. So we talked about Judge Cote mentioned that she wanted to address that big question in the room. So the big question is whether there is enough science for a case asserting autism, ADHD for Tylenol. And so she created a phase 1 discovery. So phase 1 discovery deals with general causation. And so essentially general causation asks, can this drug or device actually cause this injury? So here, can autism and ADHD actually be caused by Tylenol in general? And then there's specific causation, which asks, did it actually cause it in this particular plaintiff? And so this phase 1 is about general causation. And so she ended up setting very accelerated expert deadlines that we don't typically see in other MDLs. There was a discovery for phase one discovery. That was very accelerated. She issued this discovery order in January, and we were going to have phase one discovery completely finished by the end of May. So, well, June 2nd, pretty much the end of May. And so she essentially said in that initial discovery order, plaintiffs need to designate what 5 people from Johnson & Johnson's company that they wanted to pose on this topic, and then they will need to gather documents from those individuals and produce them to you. And that was the work of the discovery committee that I'm a part of, and we had a whole team that reviewed those, and they set a deadline for May 5th of the substantial completion of those documents, and then those depositions started within a week or 2 after that. And so, just to give you context of how fast this is going, May 5th was when they were supposed to have the substantial completion of all their documents produced. That was the deadline. The first deposition was May 19th, so just a few weeks, just 10 days or so later. And so they produced over 200,000 pages of documents on that May 5th day. And so we were obviously just getting everyone hands on deck, and we were it's surprising to me how fast this went, but we were able to review all of those by May 12th, I believe. And so those depositions started, epidemiologists from Johnson & Johnson's chief medical officer. And then during this same kind of period, the Acetaminophen-MDL's science committee, which Roger's the head of, was working kind of side by side with us, but on the track of getting these experts ready with their reports. And they just turned those reports in on Friday, and Roger and that team are so excellent. Like just being in the room with them, I mean, shows just how far I am in my career to really getting to the top of this mass torts world. It's really been excellent to see what they've done, and they've put together these excellent reports. But that is just the broad version of literally a very accelerated process that's been happening these last 5 or 6 months since we got those started up. So we did those 5 depositions. What's happening next is we're reviewing more documents from the retailer defendants in the case, who manufactured Tylenol, or manufactured acetaminophen, but under their own kind of brand name. And then obviously next the defense will submit their expert reports, and then we will start doing depositions of experts, and we'll keep marching forward.
Hey, Ryan, thank you very much. And I will take issue with one thing Ryan said about the preemption not being difficult. Preemption to me is an extraordinarily difficult concept. There are a lot of very unique issues that come up, and it requires somebody to have really studied the law to understand how that law applies to those very specific issues. And I am not one of those people. Ryan is. I am not. So I take issue. It is very, very difficult. But want to thank everybody for joining us today. Thank you, Ryan, for the update on where we are in litigation, and some of the legal hurdles we've had and will have in the future. I'm kind of focused my presentation on where we are in the science. And so I kind of want to jump next into, the science that is underlying the claims that we have. So scientists believe that autism can result from multiple things. I mean, there could be genetic mutations. There could be environmental factors that impact how a gene expresses itself during development. And really the latter is what we're focused on. There are numerous kind of factors that can have an impact on how a gene is expressed. One of those is acetaminophen. Others include pesticides or heavy metals or Depakote, which is a medicine that has been found to impact how a gene expresses itself. And ultimately, there's a warning about Depakote causing ASD and ADHD in the label. But one of the puzzling things about autism in this country is the increase in the rate of autism we've seen since 1980. And I think what we know in the country is that a lot of the pesticides that we know are issues have now been banned. We've banned leaded gasoline and lead in paint. And so it's not like we've seen this catastrophic avalanche of environmental factors that have increased since 1980 that ultimately be causing these potential problems. So when we started looking at this, the sheer number of these increases was pretty astonishing to me. Several decades ago, 1 in 1,000 kids were diagnosed with autism in the US. I think in 2009, it was 1 in 100 kids. I think more recently, 2022 was 1 in 36 kids being diagnosed with autism and ADHD. And so I think one of the questions probably each of you have logically is, well, is it the result of better diagnostic tools? Is it the result of more awareness from parents or physicians? And there was actually a study that looked at that. It was a peer-reviewed study, and it found that 25% of this increase that we're seeing is actually the result of better diagnostic tools or better parental or doctor awareness. And the rest of it is the result of something else. Now, what is that something else? Well, we know that prior to 1975, Tylenol had limited sales. It was advertised mostly to physicians. Around 1976, J&J changed its advertising to directly advertise to the public. And we know that at that point in time, the sales of it skyrocketed from 1955 when it was first marketed till recently. I think in 1976, sales had become number one. Right now, 2021, sales were 9.4 billion. I think it was expected to grow to over 14 billion by 2031. So it is significant. Now, one of the most compelling pieces of evidence, I think, linking acetaminophen use to autism and ADHD is the rise in autism rates that we've seen that have actually coincided with the increase in Tylenol usage. One of the things that happened in 1980 was that there was a Reye syndrome scare. I don't know if any of you were around 1980 and remember that there was a scare with aspirin, that aspirin was causing Reye syndrome. And as a result of that scare, there was a recommendation for doctors to start using Tylenol instead of aspirin. One researcher, his name is Schultz, actually compared the nationwide shift from using aspirin to acetaminophen against the number of children with autistic disorders eligible for service in California, born before and after 1980. And there was actually a correlation between the increased rate of autism that they were seeing in California with the increased rates of Tylenol usage. Now, very interesting, and I said this in our last webinar, so I'm sorry if I'm repeating myself to some of you that may have attended the last webinar on this. But there were several instances in history where the use of Tylenol plummeted. And they were actually the result of J&J adding a liver warning to the Tylenol product that actually was explaining how Tylenol had been associated with liver failure. And in fact, it's the leading cause of liver failure in this country, if you don't know that. But they actually looked at these other instances where Tylenol sales had plummeted, and they were the result of cyanide tampering scares. And I don't know if any of you remember in the 80s when there were instances where someone was tampering with Tylenol product. tampering and adding cyanide, and it was killing people. And it was, as a result of those, there were recalls. And as a result of the recalls, obviously the sales of Tylenol plummeted. And what's real interesting is after each of those plummeting sales periods, there was a decrease in the diagnoses of autism and ADHD in California. After each of these recalls, there was a decrease in the number of diagnoses. And that's really something that we kind of consider this de-challenge issue. And it's a factor to consider when you're actually looking at whether an observed observation or observed association within the literature is causal. It is whether there is challenge and de-challenge. And here, I believe that we have that specific factor covered. Sorry about that. So another thing that I think is really interesting in the litigation is Cuba. So an important thing in looking at these particular issues is whether can you attribute the issue to a specific area. And an example of that is the thalidomide. Thalidomide was a product that was approved in Europe for morning sickness. It was never approved in the United States for that issue. And all of a sudden in Europe, they started seeing certain birth defects associated with the arm. And and we weren't seeing those defects in the United States. These particular defects were something that were astounding, affecting, I think it was about 10,000 kids in Europe. But we weren't seeing the same types of defects in the United States. And so what scientists were able to do is look and compare the geographic areas and compare what type of products had been made available to Europeans that had not been made available to people elsewhere. And they found United States as the example. They were able to pinpoint the introduction of thalidomide into the market, and were able to recall that, at which point the defects stopped. We have something very, very similar in Cuba. Cuba may be disadvantaged in a lot of ways, but their healthcare is free. 99.7% of Cuban residents are vaccinated. However, they have their issues. I mean, they're still using leaded gasoline. They're still driving 1950s cars. I think their environmental laws are not nearly as good as what we have here in the United States. However, in Cuba, there is a very, very, very low rate of acetaminophen usage. And in fact, one of the things, I'm taking a step back, in Cuba, acetaminophen is not available to pregnant women and over the counter, and it is rarely prescribed to pregnant women at all in Cuba. And what we see is that in Cuba, the rate of autism is 298 times less than it is in the United States, which is huge. So I think that we can use this ecologic data to help us in describing really why the acetaminophen may be the cause of this epidemic that we have versus other substances or factors. Now, one thing that's really interesting is that acetaminophen has never, ever been proven safe with respect to neurodevelopment. There was actually a study, it was a recent study from 2021 that actually looked at the claims that were being made about the safety of acetaminophen, trying to explain why there were recommendations for pregnant women to use acetaminophen. And ultimately, they found that all of that was based upon several studies that were referencing the liver. And what they found was that because in fetal development, the fetus doesn't, the liver is not active within the fetus until essentially there is a birth. The same types of injuries that happen to an adult liver are not happening in a fetus. And therefore, because they weren't seeing those liver injuries, they were able to kind of conclude erroneously that the use of acetaminophen is safe in fetal development, which we believe it is not. And I think that there is a very specific reason why you're not seeing the liver injuries in fetal development or the fetal liver like you do in the adults. And if I have time, I'll try to explain some of that later in the presentation. But this study actually demonstrates that acetaminophen was never shown to be safe for neurodevelopment. And this conclusion was consistent with emerging studies in animal models that showed exquisite sensitivity for long-term behavior to early life exposure to acetaminophen at early doses. I mean, so it was basically consistent with what the literature is showing in epidemiology as well as the animal models. To this day, there's no type of warning in any kind of acetaminophen containing product that would alert a pregnant woman to potential risks associated to neurodevelopment, ASD, ADHD, or other neurodevelopmental issues when taking during pregnancy. In fact, the warning is specific to that liver issue, and and ultimately the recommendation is to talk to your doctor. So there will be a lot of discovery on what information is being shared with doctors about the safety of acetaminophen. But from what we can tell so far, the information being shared with doctors was that the use of acetaminophen during pregnancy is considered safe and is not associated with any type of fetal issues. And in fact, for many, many years, J&J marketed acetaminophen as a category B, a pregnancy drug, which means there is no evidence of any type of fetal anomaly whatsoever, even in animal studies. And that's not the case. And in fact, the FDA has never approved acetaminophen as a category B drug. Now, the result of all of this is that women across the country and across the world are under the impression that acetaminophen use during pregnancy is safe. A recent study by Bandoli found that actually 58% of women worldwide take acetaminophen during pregnancy, most frequently for headaches. And the women that are usually taking it for the longest duration during pregnancy report using it for sleep or for pain and injury. Now, what's kind of amazing is if you look at the numbers, 9% of those women globally who take acetaminophen during pregnancy take it for 45 days or more during pregnancy. 9% take it for 20 to 44 days or more, and 13% take it for 10 to 19 days. So the amount of usage is significant, and it's because these women are being told by physicians and otherwise by the manufacturers that these products are safe for them to take during pregnancy. Now, so I'm going to try to go through some of the medical literature that we have. I know we don't have a whole lot of time to go through this, but our focus in the litigation has been various injuries. The complaint is actually drafted in such a way that it alleges injuries for ASD, which is autism, ADHD, attention deficit hyperactivity disorder, and then other neurodevelopmental disorders with symptomology consistent with ASD or ADHD. And what we have found is that the medical studies that are showing these links are not necessarily focused on ASD or ADHD, but they're focused on a broad spectrum of disorders that are consistent with a diagnosis of ASD and ADHD. And that's actually consistent with how doctors work nowadays. They're actually following this diagnostic and statistical manual of mental disorders. It's referred to as DSM-5. But DSM-5 actually looks at a lot of these disorders as a constellation of disorders within a spectrum. And that's kind of important because how we have had to analyze the studies that are available to us is to look at not just the studies that focus on ASD or studies that focus on ADHD, but studies that look at other neurodevelopmental disorders that are consistent with the symptomology of those disorders. So jumping into the science, I mean, the big question is, what does the science say? And what's really interesting in this case, and I've never seen it before in 23 years of doing mass torts, is that we actually have scientists, not only the science, the medical studies that support us, but we have the scientists that are writing those studies actually making causal connections and asking for there to be warnings placed within labels to warn women. And Ryan mentioned it earlier, but the main one is this 2021 consensus statement by Bauer. And the consensus statement is 91 scientists from around the world. And I don't know if any of you have ever worked with scientists, but to get 99 scientists together in one room or in one theory and agree with each other is consistent, or it is hard. But what they did was these 91 scientists published in agreement this statement saying that there was something here with respect to the link between acetaminophen and these neurodevelopmental disorders, and that there needed to be a warning to women to avoid these issues in the future. And while a lot of the science that we have has relatively modest effect of statistically significant increases in risk, what we know is that even small increases in effect size translate into huge numbers of injuries when we're talking about a large population of exposed people. And here we're talking about 60% of pregnant women being exposed to acetaminophen. So small, modest effect sizes can have, tremendous devastating impact on society. Now, the consensus statement provided us a lot of good background information on the science, but it took care to specifically point out that there is evidence from clinical studies on animals that are actually explaining why these injuries happen. Not only the consensus statement, but we have published medical studies from various study authors from 2016 to 2021 that also made causality statements within their papers. And I know that if any of you have dealt with this stuff before, most of these study authors never use causation language. They typically leave the question to be answered. We need a little bit more studies on this. We need more studies on this. And they're always doing that because they're essentially seeking more funding for further studies on the particular issue. But with respect to acetaminophen, we're actually seeing authors start to use causality language. And specifically, and I'm going to jump ahead because of time, but we had the Alamany case in 2021 that actually walked through Bradford Hill factors at the conclusion of the paper, talking about how certain factors have been met, including biologic plausibility, which is whether in animals, is there a mechanism of action that we can show is causing these issues, which we've got, coherence, consistency, temporality, how all of those factors were met with the information that we have, which is just so unique to the litigation. Bradford Hill, for any of you that don't know, Bradford Hill announced these causality factors back in 1965. He was an epidemiologist, and the whole point was how you can take an observed association through epidemiologic studies and actually determine whether there was a cause. And there was kind of certain criteria or factors, I think is the better word, because they're not really all required, but a certain process you walk through to determine whether there is, whether you can conclude causation. Alamany actually did a part of that for us, which is so unique. But one of the big factors that Bradford Hill, asked us to look at is there a dose response? Meaning, the more if there is more exposure, do you see more incidents of the particular injury? And we do. In this particular case, specifically looking at ADHD, we have 5 different studies that concluded that there was a statistically significant increase in risk, and that risk increased the more exposure you had. For ASD, there are 2 particular studies that specifically address dose response. For other neurodevelopmental disorders as a larger category, there are 3 specific studies that address dose response, meaning the longer there was exposure, the greater the risk. And in fact, for most of those, the longer the exposure, and I think it was around 20 to 28 days, it actually crossed over into a doubling of a risk for causation. And that's actually important for specific causation, because once you get to a doubling of the risk, there can be a presumption of causation through a specific causation analysis. The studies have actually gone through biologic plausibility as well. Now, there is a whole bunch of animal studies that have been conducted, I think starting back in 2008 and 2009, showing the biologic plausible mechanism of how acetaminophen is hurting, that are developing in those animal studies, but ultimately the developing fetus. One of the plausible ways is the endocannabinoid system, changes in brain-derived neurotropic factor, which is the BDNF levels. There are oxidative stress issues due to inflammation-induced immune activation. There are changes in neurotransmission and endocrine disruptive properties. There are multiple factors or multiple plausible mechanisms that could be causing these particular issues. And it bears noting, that back in 1975, we actually confirmed that acetamin crosses the placental barrier. So we know that acetaminophen is getting into the fetal blood circulation. And I can say, and I'm kind of trying to move quickly, that the oxidative stress is, what I believe to be the main issue here. It's the same mechanism underlying the Depakote valproic acid issue, where we've actually got a warning in the label. And I won't go into details of how it works, but needless to say, the oxidative stress issue makes sense. And I will say this: there's a substance called CYP2E1 that metabolizes Tylenol, and Tylenol, as it's metabolized, creates a toxic metabolite called NAPK. It's the only substance in the world that causes NAPK formation, and the only way NAPK can be kind of gotten rid of or depleted is through a substance called glutathione. And we know that the Tylenol depletes glutathione, and if it's depleted and the NAPK is left to its own devices, it causes cell death and all kinds of neurodevelopmental issues, which I believe is it's going to be one of the main mechanisms here. Just back to Bradford Hill, we have consistency and strength. We have 10 studies showing statistically significant association between acetaminophen and ADHD, 3 studies showing a statistically significant association between acetaminophen and ASD, 5 different studies showing that statistically significant increases in risk with other neurodevelopmental issues. And all of these are consistent, and the majority of them show a dose response. So I'm going to jump ahead. This is going to be in the slides that you get, but due to time constraints, I'm going to kind of conclude with this. We have the law on our side. We've dealt with the preemption issues. They're being appealed, but at least within the district court, the court was in our favor. The medical literature is on our side. We have consistent, statistically significant increases in risk. The scientists are on our side. First time ever. I've been involved in a litigation where the scientists were advocating for label changes long before any litigation was involved. And so I think the case is going to be and continue to be a strong case. I know that's a lot of information. I apologize. I had to go so fast. I'm going to turn it over to Mary Cam because I know a lot of you guys are going to be interested in how to identify cases. So Mary Cam, you want to take over?
Absolutely. Thank you, Roger. So, now that we have provided you guys with a great insight on some of the science supporting these claims, the next question is going to be, what makes a good acetaminophen case? What is a case you would even want to consider investigating? So the next couple of slides, we're going to talk about some case criteria. We're also going to discuss some risk factors that could potentially affect your causation argument. So first, we want to discuss the time frame. The ideal time frame is either when the child was born or diagnosed between 2013 and 2020. Now, why is that? That may seem like an oddly specific time frame, but as Roger pointed out, with the relevant medical literature linking acetaminophen use prenatally to autism and ADHD in humans really began to surface in around 2013. So that's when the manufacturer would have been put on notice of a potential issue, and perhaps most importantly, an issue that they should warn consumers about. And so the cutoff date is in 2020 based on the CARES Act that came around March of 2020. And that basically changed some things for over-the-counter medications. It basically gave the monographs the force of law. So there is the question that's open-ended on whether or not post-March 2020 cases may or may not be preempted under the CARES Act. And so the overall takeaway on the time frame is that a birth or diagnosis between 2013 and 2020 can hopefully prevent some setbacks in a potential case because there are no issues as to whether the manufacturer was put on notice, and you can avoid some preemption issues. And so obviously we want to next consider what injuries we investigate. And, with autism, there's an entire spectrum of disorders that are linked in the medical literature. And so all of the ones you see listed here fall within the purview of the autism spectrum disorder. But the remaining one that you see at the bottom is ADHD that we investigate. And, while ADHD is not considered part of the autism spectrum, it does mimic many autism symptoms. And there is still literature associating that with ADHD as well. And one thing to remember is that ADHD kind of falls within the ultimate purview of neurodivergence. And so then what products do we investigate? In general, we would want to investigate and you would want to find cases where the mother used either brand name Tylenol as well as store brands or generic paracetamol. I will say though, you are hardly ever going to see paracetamol. You'll almost always see Tylenol or generic acetaminophen. And it's important to note that aspirin and ibuprofen often get confused with acetaminophen products because they are pain relievers. But when you're intaking a potential client, you want to make sure they are clear that they took Tylenol or acetaminophen and not aspirin or ibuprofen. And so what can we not handle? As Roger mentioned, the ideal time is to have between 20 to 28 days of use. And note that does not have to be consecutive days of use. It can be sporadic throughout the pregnancy. The next thing is ideally and practically, you need the mother on board to pursue the claim. To have a good case, you're going to need to filter out some risk factors in the mother, and we'll talk about those in a minute. And you also ideally need to have the mother to have legal or physical custody of the child. Last on this, you would probably not want to handle an injured adult claim at this time. The main focus of the MDL is minor children. And this is for a variety of both practical and legal reasons. Practically speaking, it's going to be difficult, if not impossible, to obtain medical records that far back for an injured adult. And then legally, you have the hurdle of a lot of states allow minor tolling while they're still a minor, but there may be some statute of repose issues that may set your minor tolling and create some issues with that. So you always want to be mindful of those. And so then some risk factors, in any drug or device case, you're going to encounter some pre-existing conditions or just factors that could create causation hurdles. So the next couple of slides, we're going to talk about some of those. And it's important to note, this is a very, very case-specific evaluation you need to make if you're intaking a potential case. And you must note you need to evaluate risk factors in both the mother and in the child. And so the injuries you see listed here is what us at Beasley Allen consider possible automatic disqualifiers. As discussed earlier, genetic mutations in the child would make your case pretty difficult, and likewise, a significant family history of the same disease may indicate a potential genetic issue. And other disqualifiers you'll see here, like gestational diabetes, preeclampsia. There is independent literature linking these to neurodevelopmental disorders themselves. So it would make, and these often increase the rate or risk 2 or 3-fold. And so we also have premature birth listed on there. We consider 36 weeks or earlier to be premature, and that's something you would also want to maybe consider a disqualifier for the case. And so the other factors that we have listed here, these are somewhat risk factors, but we sometimes call them cofactors. Basically, these are ones that could potentially increase the risk, but maybe not as much as what we discussed earlier with the automatic disqualifiers. And so any like autoimmune disorders in the mother, that would be such as lupus, rheumatoid arthritis, or maybe MS. And the last thing you want to note when you're evaluating some of these other potential cofactors is if there's any kind of frequent infections or illnesses during infancy, or if the child was under any kind of respiratory distress during the time of delivery, and perhaps one that is so severe that it would require a stay in the neonatal ICU. And so the overall takeaway from this, if you can't tell, is that the less complicated the pregnancy, typically the better for the case. And hopefully you'll have a case with a full-term pregnancy as well. And there are 1,000% more risk factors to consider in the mother. So you really want to make sure you are apprised of all of her medical conditions, prescription medications, especially those taken while pregnant, and any other medications taken while pregnant, including over-the-counter drugs. So you also
let me add in, because we're short of time, and I want to make sure everybody's clear. These are risk factors that our firm is focusing on. We're not trying to make a statement as to whether there's a medical viability of any of these defenses. Other firms are considering these cases differently. And the 2013 timeframe that we're using, again, that's a Beasley Allen time set. There is literature available prior to 2013, so a lot of firms are going further back than we are. But so I don't want you to think that we have kind of set that, and that is the only as far back as it can go. Other firms are looking at that differently.
Absolutely. Thank you, Roger. Yes. And we are still taking a look at cases that are pre-2013 because there is that literature, and because once we get more into discovery and find out what defendants knew before this 2013 period, which we have reason to believe they probably did know a good bit of acetaminophen's risk on neurodevelopmental disorders in children. We still, take cases outside of that time frame. We were just generally speaking, the ideal time frame when looking at a case based on the first objective study that was conducted in humans would be around 2013. But yes, absolutely. Thank you, Roger. And so last thing I was just going to mention is that the most risk factors you need to look at are going to be in the mother. And so you also want to account for her social history, any kind of prior drug use, smoking, drinking history. You want to make sure that the takeaway is not only the less complicated the pregnancy, the better, but it's also to make a very case-specific evaluation when you're intaking a potential case. And it's also important to note that, these children are suffering. And so you always want to do so with respect for both the mother and the child. Because what I found in talking with clients, a lot of time they think that this is the mother thinks it's her fault. And so, it's all about, talking with clients and making sure they understand that it's not, and that there are so many factors that could play into the case, but that, acetaminophen, there is a very, very strong link, as Roger and Ryan have pointed out.
Yeah, thank you very much. And David, I know we're out of time. We've run.
No problem.
Yeah.
No problem.
Yeah.
And I'll tell you, on behalf of all of our viewers, I want to thank our entire panel for a really thoughtful and thorough presentation. I am always amazed by the work that my partners do, and I truly enjoy learning from them. And I think you guys have addressed most of the questions that our viewers have submitted today. So for those of you who may have missed our earlier announcements, I'm going to jump right to them. By the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link. You can email that completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys participating by phone, please email us your name, phone number, and state bar ID number. You're going to need to send that to webinars@beasleyallen.com to ensure you receive full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout the year. All of them will be profitable, helpful, and hey, you can get an entire year's worth of CLE credit just by viewing our webinars. So thanks again to everyone for joining us today. Thank you for supporting our Beasley Allen webinar series. Have a great rest of your day.